Welcome to the Trust Factor Radio, bringing you interviews and insights to unlock the power of the subconscious mind to create authority, credibility, and trust. With your host, the Authority Architect and best-selling author, Neil Howe.
Hello, welcome to the show. This is your host, Neil Howe, and today my special guest is Kristin Dittus. She is an attorney practicing in Denver, Colorado, with her master's in tax, and she helps individuals and families with estate planning, elder law, and probate. She works with her clients to create a well-thought-out plan that can best provide for and protect themselves and their loved ones. From young parents who are concerned with naming guardians to families with more complex assets and business entities, her 15 years of experience guides clients to the most economical solutions to effectively handle their legal questions. Kristin Dittus, welcome to the show.
Thank you so much for having me on today.
Well, great. We got a little bit of information about who you are and what you do, but let's get a little bit clearer about the kinds of people that you help. Are there any specific kinds that you like to help more than others?
So anyone who is in need of an estate plan is a perfect client for me. And this could include young parents who have children and they're concerned about who to name as guardian or who would take care of their children if something happens to them. It also could include adult children who are planning for their parents if their parents might need long-term care. And just kind of everyone in between who is concerned about passing assets to their loved ones and discovering the best way to do that.
Okay, so let's get clear on what exactly an estate plan is. For those that don't know or haven't really thought about it yet, could you really describe what that is for us?
So an estate plan is going to cover things that happen after you're gone, but it's also going to cover how things are administered during your lifetime if you're unable to act. So some of the foundational documents would be a will, which is only effective after you pass away. And so during your life, you want to make sure you have powers of attorney in place that will allow someone to make decisions for you if you cannot. And that often involves a financial power of attorney, which is also called a general or statutory power of attorney. And that gives pretty broad powers on being able to, pay your bills and make sure your assets are taken care of if you are ever in an accident and you are unable to pay your bills for yourself. Or at the end of life, we might have some incapacity, and that power of attorney will allow someone to take care of you. And without it, you would otherwise have to go to court, or your loved one would have to go to court to qualify to be your agent. And that can be very cumbersome and expensive. So a lot of the theme behind estate planning is a little bit of planning ahead of time will prevent a lot of cost and headaches later on when you're in a crisis.
Right, interesting. And that's something that probably many people don't think of or leave too late, is it?
It is. You get people who are very proactive and they're infrequently, or also if you know a crisis might be coming down the road, if you sense your parent is having some memory loss, it's a good time to address any problems that could come up before they become full-fledged problems. And, when you're in a good state of mind and you're healthy, that's the best time to think about how you want things to play out if you are unable to make decisions later.
Now, you mentioned that there's different stages of life where people might think about this, but in general, what stage of life do people really think, I need an estate plan, I need to get my affairs in order now?
Usually having kids is the biggest kind of motivator to bring people into my office, or once people have a business that's, running successfully. If something happened to them, it's important to have a plan in place for someone to take over for you, even if it's for a short-term period of time. And then, the retirement phase is another really important time to start thinking about how to plan for your assets, because there's a lot we can do to protect assets from the cost of long-term care if we think about it ahead of time.
Well, I'd like to get into some of those things in a minute, but estate planning is one of those things that you help people with. There's also elder law and probate. Can you explain those?
So elder law is kind of a broad definition. And for me, elder law tends to be when we're concerned about someone needing long-term care, which would mean we probably have a memory issue, it's like dementia or Alzheimer's, and the person would have to go into a nursing home. And while people are married, there's a lot of opportunity to protect assets, where one of the things I tell my clients is if we leave everything outright to a surviving spouse, then all those assets are going to be subject to creditors, and it could interfere with their ability to qualify for Medicaid if they do need long-term care.
That's something that I'm going through right now with my father-in-law. So I'll definitely have to get more information on that. But let's cover probate and what that is.
And probate is, so the planning phase happens before you pass away, and then probate happens after you pass away, and is essentially the administration of your estate. So the person in charge, in Colorado, we call them a personal representative. They're going to take a look at your assets, take a look at your liabilities, and after they pay off those liabilities, then we're going to make sure your assets go where they're supposed to, whether it's to your spouse, your kids, or to a trust for those loved ones.
Mm-hmm. All right, well, let's break these down a little bit and look at some of the main issues when it comes to estate planning. What kind of problems do you see people dealing with when they come into your office?
So most of the time, people are coming in a little bit ahead of time, but they're thinking about problems coming down the road. And we have options when we want to pass assets to loved ones, which is we can just give them the money outright, which means it's theirs and they can walk away and make any decision they want to after. Or we can give them assets in trust. And a lot of times I'm an advocate for a trust, especially for estates that are of moderate wealth or above, because it allows for a significant protection of those assets after the person passes away. In the case of a spouse, which is often called a marital trust, if it's just going to benefit the spouse. If it's a younger family with younger children, it might be a family trust, so it could include both the spouse and the children. And the benefit of the trust is the person who it benefits can also be in charge. They can be the trustee who manages the trust, and they can be the beneficiary as long as they follow certain IRS required rules on the distributions, which of course we go over in the meeting. But then it prevents creditors from being able to go after. If it's in a marriage, we might allocate 50% to each spouse, so that 50% would pass in trust to the surviving spouse. And those assets would be highly protected if it was a young person, if they got remarried, if they ever faced the need for long-term care or medical creditors. So it really sets people up to prevent problems down the road.
And what happens if they don't set up a trust?
Well, then the assets just pass outright. And then they're kind of subject to all the problems that you and I would face on a daily basis with the money we have. So a lot of times, one of the techniques I can use in a will is to say, when I pass away, I want assets to pass in trust to my child. But if they don't need the trust, they can disclaim the assets and they can receive the assets outright. And if the child is set up to receive assets outright, and they happen to be going through a divorce, or they're dealing with an IRS problem, or they're going through a bankruptcy, then all of those assets will kind of essentially pass right through the child without the trust and go straight to the creditor, rather than be protected for the lifetime of the child.
That's certainly not something that anybody would want. So protecting from the creditors and tax advantages are a couple of things. Are there any other benefits to creating a trust?
But I will say one of the things that motivates parents when I talk about setting up a trust for their child, because there's a little resistance sometimes because they don't want it to be too complicated. So we do everything we can to keep it simplified. But when I tell them that if their child ends up in a bad marriage and they go through a divorce, any assets that are in trust would not be countable as dividable at that divorce, where if they had that money outright, there's a good chance it would get wrapped up into the divorce proceedings and might be divided between the child and their divorcing spouse.
Mm-hmm. So what are some of the tax implications then from if you put your money in a trust? How does that benefit not having to deal with the IRS and taxes?
So there's kind of two levels of trust which are important to understand. There's a revocable living trust, and that can be set up during my lifetime. And unlike a will, that becomes an active vehicle right away. So I would transfer my assets into that, and it provides a management for those assets. It can be especially helpful when a parent is aging and we're concerned about the parent managing their own money. If they put it into the parent puts it into a trust, then the child can be the trustee and help them manage it. Now, when it's a revocable trust, there's not any tax advantages available. It's going to be the same as their own tax ID. But when we're leaving assets to a spouse and we create that marital trust, we're going to design the trust so it's called a QTIP, or Qualified Terminable Interest Trust. And that's going to allow the underlying assets, while they're protected in this bubble of the trust, it will also allow those assets to get a step up in basis upon the death of the surviving spouse, which is a huge advantage, especially in an area like Denver, where we see a lot of appreciation on homes. We don't want to miss out on getting that step up in basis to fair market value upon the death of the surviving spouse.
Definitely. Now, with an estate plan, is it basically the same thing for every person, or is it really well customized for each individual?
It's extremely customizable, and it's part of the fun of estate planning is finding out what the client's goals are. Part of the process is figuring out what assets they have, because different assets plan differently. For example, retirement assets are often deferred compensation. So if someone has a large retirement package, it might have slightly different rules when passing it on to a beneficiary than a cash asset. And for those clients that are charitably inclined, you can get the biggest bang for your buck giving from an IRA that's deferred compensation, because a charity doesn't have to recognize any income tax, and they'll get much more of that dollar than they would if they pass it to a child who's in a high income tax bracket that would have to recognize that income as ordinary income.
Right. So there's definitely lots of things to think about when it comes to your estate planning. What are some of the misconceptions that people have about planning their estate?
I think the biggest misconception is that there's not a lot of flexibility or options when you leave assets to your loved ones, when in reality, there's quite a bit you can do. We have the option of leaving outright or in trust. And then if we have children where we're concerned about their behavior, we can also put incentives in the trust to help encourage good behavior. And in one family I worked with, they were willing to match the child's salary as far as distributions to try to encourage them to work more because they didn't have the best work history. And there's other incentives you can use to try and, for example, at some point we can give the child the ability to become the administrator of their own trust. And oftentimes parents want them to get a degree or show that they don't have excessive debts for someone of their age before they're willing to allow them to take over the reins on the control.
All right. And are there any specific ages to where a child might inherit money from a trust, or can that be set to any age that they decide?
So under the traditional estate planning, oftentimes we would see trusts that gave assets outright to children at 25, 30, and 35 and do them in equal 1/3 installments. But under modern estate planning, we often put the child as a beneficiary of the trust, which means they can receive trust assets for oftentimes health, education, maintenance, and support at any age, and the trustee would make sure they were getting those distributions. And then at 25, we might make them a co-trustee so they can start to get involved and see how the trust works. And then at 30, as long as they were personally and financially responsible, we might let them take over the reins so they could be both the trustee and the beneficiary of that trust.
Now, let's talk about the mechanics of the trust. Is trust something that you can set up yourself?
Well, there's always an option of trying to set up something through one of the legal softwares, but a better plan is to go to an attorney because they're going to be able to customize that trust. And as an attorney, we have the benefit of law school, continuing education, tax school, and we know how the different rules interplay to make sure you get the highest level of asset protection as well as the most flexibility for getting access to your own assets.
Yeah, I'm sure there's a lot of people that try and look into it themselves and do it themselves, but ultimately they probably come back to you at some point, Kristin, and say, I kind of messed up. What big mistakes are there for them to make?
Well, there's quite a few. But essentially, for example, I had a client come to me recently who had an estate plan done by someone who had just started doing some estate planning and was really doing it on the side instead of doing it as their main practice, where for me, it's a specialty. So I really spend all of my time, dwelling in the possibility of what can be done with estate plans. And in this case, they knew that their mother was showing signs of dementia, and they went to this attorney for guidance, and he, instead of getting assets out of her name, he put things in joint tenancy. And what happened was the son of this woman unexpectedly passed away beforehand in a car crash. And at that point, she had dementia, and he was the only beneficiary of her assets. So she had no plan beyond what happened if something happened to her son. And another component of this situation was that she had decided to stop talking to her other family members and had kind of lost communication with them and had told them she didn't want to speak to them again. But because she didn't have anything else set up in her estate plan, and because she wasn't able to communicate it by the time her son had passed away, all of her assets, which were substantial, ended up passing to all these people she had decided not to continue a relationship with. And I think if she was living, that is something she would not have wanted to have happen.
Right. And that is something, unfortunately, that happens more and more. There's definitely situations where families fall out, but there's also a huge increase in the number of people with dementia and amnesia. So if you start seeing signs of those kinds of things, what are the important things to do right away?
The most important thing is to get on track for a long-term plan. So come to an attorney. The most important document for someone with memory loss is going to be that power of attorney, because oftentimes a nursing home won't even accept someone unless they have a power of attorney to sign them in and become responsible for paying the bills. The other thing is, if there is a need to qualify for Medicaid or consideration that it might be needed down the road, many facilities will only take someone on Medicaid if they've private paid for a certain number of time. And that could be 2 to 3 years of time. And I think the average monthly cost of nursing home care in Denver is around $10,000. So you're looking at spending, $120 a year for 2 to 3 years before they're going to qualify. So if you can plan ahead and make sure you're in a facility that would accommodate this person long term, then it will allow you to be in a good position and not be shocked once the eventuality comes to light.
Right. And I think that would shock a lot of people, the amount it actually takes to pay for long-term care. What options do people have if they haven't planned for this?
Well, oftentimes children will step up to help pay, so if someone kind of pays down the assets that they have and they're running out of assets, it's often left to family members to step up and help out their parents. And that's a situation we don't want to put the children in, because many adult children are in a situation where they're helping out both their parents and their younger generation children, and it can be very financially stressful.
Definitely. So talk to me then about probate, and this is after you pass. When does the probate part kick in, I guess? Is that the reading of the will and what happens
Yeah.
that's in there?
So probate actually has, there's quite a bit of strategy sometimes that can go into a probate, and every probate is state specific. So the rules in Colorado are going to be very different than the rules in New York, where I came from. And Colorado, we're extremely fast, we're very streamlined and efficient on the probate process. So oftentimes if clients come from California, they'll be nervous about using just a will, but in Colorado, it's no problem. So after someone passes away and we take care of some of the essentials that go on with the loved ones, I'm often contacted to discuss how to move forward. And in Colorado, we have a simple set of forms that are available online to any lay person, but oftentimes people get frustrated and would just rather have the attorney take care of it. We submit those forms once we have information about who will be in charge of the estate and who are the beneficiaries of the estate. And then the court, oftentimes within a week to 2 weeks of submitting the paperwork, will issue what they call letters of administration or letters testamentary. And then the representative of the estate with those letters can now begin to conduct business on behalf of the estate, to pay off debts and to, figure out what assets are where now that they have the authority to speak with financial institutions.
Well, there's definitely a lot to go over, making sure that everything is prepared just in case something happens, or if you're coming into the final years. Are there any reasons that prevent people from setting up an estate plan?
I don't think there would be any reason to prevent someone from setting up an estate plan. I think, in the beginning of life, we have a few less assets. There's not as much need to direct where those assets go. But once you accumulate some items, and, also for many clients where maybe there isn't a natural progression, like they're not married, they don't have kids, it's even more important for them to state where they want assets to go. And a lot of times charities are a great beneficiary, or there could be nieces and nephews. But even young adults, like oftentimes parents are surprised to learn when their kids go off to college, if they don't have a power of attorney in place for their children over 18, then if something happens to that child, they aren't able to step in and help them in any way unless they go back through that court system, which can be cumbersome and expensive. So, really from the time you can sign a contract, it's a good time to get a plan in place.
So are there any fears that might hold people back from doing that? Like maybe they think it's just too confusing, or maybe they think that it doesn't really apply to them at this stage of life?
I think yes. And I think sometimes the cost can be a little prohibitive.
Okay.
But what I would say is at the very least, if you're intimidated by the cost of doing an estate plan, go at least for a consultation so you know what your options are. And then there are attorneys out there that work on a broad range of prices. So there's often someone that would be willing to match your economical needs. And if you perhaps don't have the financial means to go for someone who has a bigger reputation, they can often recommend someone who is younger in their career and is at a better price point for you.
But generally working with an attorney, you're going to get that investment back just by making sure that you're doing the right things and saving a lot more money in the long run, right?
Definitely. And when we look at someone where we're looking at saving potentially half the value of their assets from creditors, that's a significant savings. And oftentimes the lawyer fees are well worth the investment based on the money you're going to get back, and also just for customizing a plan that's going to be exactly what you want. So everything is taken care of. And that peace of mind tends to be what my clients are happiest about when they leave.
Definitely, you just read my mind. Peace of mind was exactly what I was thinking right there as well. What about if somebody sets up an estate plan, maybe in their 30s, they've settled down, they're having kids. and they reach their 50s and they haven't really updated it. How often should an estate plan be updated?
So we like to say every 5 to 10 years, you should take a look at it and make sure it's accomplishing your goals. And especially now, there has been a lot of changes in our tax code in the last 10 years. So when people come to me with documents more than 10 years old, there's been a lot of changes in modern estate planning and also changes from the tax law, so we can better customize it to what they want going forward.
And how long does it generally take, or how much time is it for the actual client?
The client, usually it involves, like in my process, I send out a questionnaire, which helps them get their assets and their life organized. And it's a good process to go through just to kind of identify what you have and where it is. Then we meet for approximately an hour. And then in about 4 to 5 weeks, I'm able to get drafts back to them. We go over the drafts together, and then they come back in to sign. So the process takes about 6 to 8 weeks total.
Kristin, give me an example of how this process, setting up an estate plan, has really helped out somebody. I know you've dealt with many cases. Are there any that kind of stick in your mind as to, they're just so thankful that they got your help and got their estate in order?
There is. And when I talked about probate, the other element of probate is there's a little bit of strategy depending on creditors that you might be facing. And in Colorado, the creditors have 1 year to pursue a claim against someone that has passed away. And in this case, I'm thinking of a family came to me, husband and wife, and he had been diagnosed with late stage cancer. So we were able to set up his documents, and his wife didn't want to be in charge of the management. She had had some challenges in the past with finances. So we were able to set up a trust for both his wife and his children, which was going to divide the life insurance into those two trusts. And also we passed half of the house into the trust. And because they came to me with enough time, we were able to set up the trust and then direct assets towards it with beneficiary designations. And those beneficiary designations allowed us to avoid probate and avoid the creditors making claims on his estate, because unfortunately he did accumulate around $400,000 in medical bills due to this cancer. So, we were able to make sure that all of his assets went to the beneficiaries and then were protected for them. And it also was really easy and seamless. So when he did pass away, it was one less thing his wife had to worry about.
Right, and it comes back to that peace of mind again, making sure that you have all these things covered. Well, we've definitely covered a lot of information about what you do. Kristin, what inspired you to become an attorney and work on estate planning especially?
Well, I was going to say, I really liked watching Ally McBeal, which I don't think was the proper reason, but once I finished law school, I found a lot of the jobs were very adversarial and litigation and divorce. And I thought maybe I made a mistake in becoming a lawyer. But luckily, my mom, who went to law school just a year before me, she had always wanted to do estate planning, and she helped get me into it. And I have to say, this area is really about people that are concerned about their family well-being. They're concerned about leaving the next generation better off than they are. So it's an extremely rewarding area to work in and to kind of work towards that family cohesion of making things better than when people come in.
So you've been helping a lot of people over the last 15 years. If there's any lesson that you learned early on in your practice that still impacts how you do business today, what might that be?
I'm a huge fan of education. So I think I go to 3 conferences a year, and the more I'm involved in my community and the more I'm involved in the modern trends, the better product I can deliver to my clients. And the happier I am knowing that I've given them the best possible product when they leave my office.
So last question, what's one thing that we might not have covered yet that you would like to mention before we
Oh, that's a tough one. I think we've covered pretty much everything. I guess there's one other thing I would say is there's a lot with modern drafting in estate planning. And one of the modern tools that we use is something called a trust protector, which has been left out of a lot of the older estate plans I look at. And a trust protector means if I create a trust for my family, my wife, my kids, this person has the ability, once it becomes irrevocable, to go in and make updates to the trust as decided on by the person creating the trust. So it's a modern way to avoid having to go to court to make changes, and make sure that even if there's a change in law after we create the trust, that the creator's intentions will always be carried out.
That's a great final thought right there, Kristin. If somebody wants to reach out to you, and I know people will be thinking about getting their estate in order, you're in the Denver area, what is the best way for them to reach out to you?
The best way is through my website, which is my last name, D as in David, ITTUSLAW.com. And then also phone number is 303-730-7930.
Well, excellent, Kristin. I really appreciate all the information that you have given us today. Definitely a lot to think about here. We've been speaking with Kristin Dittus of Dittus Law in Denver, Colorado. Kristin, thanks very much for being my guest on the Trust Factor Radio today.
Thanks so much, Neil. This was a great time.
To our listening audience, if you like what you hear, hit that like button and share, and we'll see you next time on the show.
You've been listening to the Trust Factor Radio with Neil Howe. To learn about the resources mentioned in the show and to listen to past episodes, go to thetrustfactorradio.com. To get a copy of the book, The Trust Factor, go to thetrustfactorbook.com. If you are ready to act now and build your authority, credibility, and trust, schedule a consultation with Neil at theauthorityarchitect.com.